Good afternoon, everyone. Thank you very much for the invitation and introduction. Today, I'm going to speak about establishing a comprehensive international organization for artificial intelligence and quantum computing oversight. This presentation is a joint research with Dr. Ali Mostashari also in New York. As we navigate the rapidly evolving realms of artificial intelligence, AI, and quantum computing, the significance of robust governance in these domains cannot be overstated. This presentation proposes a policy for establishing a comprehensive international organization dedicated to overseeing developments in AI and quantum computing, addressing current shortcomings. I'm sorry, it's a bit. Addressing current shortcomings in global governance efforts. Current governance efforts in AI predominantly focus on regional initiatives such as the United States Executive Order on Safe, Secure, and Trustworthy Artificial Intelligence, EOAI, and the European Union's AI Act. However, these efforts, while commendable, exhibit certain limitations that necessitate a more global and inclusive approach. The US has made significant strides in AI governance with the Executive Order AI, which aims to develop federal guidelines and principles on AI usage. This initiative is complemented by the AI Bill of Rights and voluntary AI commitments contributing to a more coherent framework for AI governance in the nation. A notable concern in existing US AI legislation is the assumption that most AI technologies carry low to no risk. This categorization overlooks potential risks in everyday AI applications. Legal scholars have urged for reviewable criteria to support these classifications, highlighting the need for more nuanced regulations. In Europe, the AI Act proposed by the European Commission represents a milestone in AI legislation aiming to safeguard health, safety, and fundamental rights. The Act calls for the establishment of an AI office to enforce and supervise these regulations across all EU member states, presenting a unique opportunity for researchers and policymakers implementing the AI Act uniformly across all EU member states, each with its own legal systems and cultural contexts, presents a significant challenge. Ensuring that all countries are equally prepared and equipped to adopt and enforce these regulations is critical. The AI Act permits self-assessment for high-risk AI applications, requiring developers to disclose methodologies for data acquisition and processing. However, there is a pressing need for an independent verification system to ensure compliance and mitigate potential biases in these self-assessments. Regulating emerging technologies is a delicate balance between fostering innovation and protecting citizens. Drawing lessons from the regulation of medicines, GHG emission control, AI governance should prioritize transparency and independence of effectively safeguard public interests. We propose the formation of a global entity, not just encompassing government agencies, but also private companies, nonprofits, and civil society organizations. This organization will address international security concerns, protect critical infrastructure, ensure equitable benefits from AI advancements, and establish universal AI ethical standards. Some of the focus areas to be tackled by this organization include: 1, international security, tackling AI-enhanced disinformation and political manipulation. 2, infrastructure security, developing strategies against AI-driven cyber attacks. 3, equitable benefits for AI, promoting inclusive AI policies for balanced global development. 4, AI ethics, formulating universal ethical guidelines for AI use. Here is our proposed structure: Central Governing Council. This top-level body would consist of representatives from member countries, industry leaders, academic experts, and representatives from international organizations. Its role would be to set broad policies, strategic directions, and goals. Regional committees. These committees would operate at a continental or regional level, for example, Asia, Europe, Americas, Africa, to address specific regional concerns and ensure that global policies are adapted to local contexts. Specialized working groups, focus groups dealing with specific aspects of AI and quantum computing, such as ethics, security, economic impacts, and technological advancements. These groups would consist of subject matter experts and stakeholders. Secretariat, a permanent administrative office responsible for the day-to-day operations, coordination among various bodies, and communication with stakeholders and the public. So standardization scope: technical standards for AI development include establishing universal technical standards for AI development to ensure safety, security, and efficacy. These standards will cover aspects like data quality, algorithmic transparency, and ethical AI design. We need to focus on interoperability and compatibility to facilitate global collaboration and innovation in AI. Standards will support cross-border data exchange and AI application deployment. Regular updates to standards to align with the latest advancements in AI research and technology. A dedicated expert panel will oversee the continuous evolution of these standards. And finally, encouraging adoption of privacy by design and security by design principles in AI development, ensuring that these critical aspects are integral to AI systems from the ground up. Oversight scope for quantum computing security protocols include developing robust security protocols to address the unique challenges posed by quantum computing, particularly in cryptography and data protection. Collaboration with global cybersecurity experts to anticipate and mitigate quantum computing related risks, especially in areas like encryption and secure communications. Setting guidelines for quantum safe cryptography, ensuring that critical infrastructure and sensitive data remain protected in the quantum computing era. Promoting research in quantum-resistant algorithms and encouraging early adoption among member states to stay ahead of potential security threats. Legal framework. As a multilateral treaty ensuring legal commitment from member countries, there will be an integration of lessons learned from existing laws such as the US AI Act and the EU laws into a shared set of global principles. Conversely, member countries will integrate the organization standards as amendments into their national laws, providing a seamless legal framework for international AI and quantum computing oversight. This ensures that existing national laws comply with the international framework without the need to abandon their current legal frameworks. What are the challenges? The organization's authority could be derived from a multilateral AI governance treaty signed by participating countries. This treaty would, one, establish the global framework and objectives of the organization, define the scope of the organization's authority, such as setting standards, monitoring compliance, and facilitating international cooperation, and allow the organization to make binding decisions within its scope, subject to the terms of the treaty. Challenges are for achieving international consensus, convincing a diverse range of countries with different interests and priorities to agree on common standards and enforcement mechanisms is one of the challenges. Another challenge is balancing sovereignty with global standards, respecting national sovereignty while enforcing global standards could be a delicate balance. Also, rapid technological evolution, keeping up with the rapid pace of technological change in AI and quantum computing to ensure that standards and regulations remain relevant and effective. In conclusion, the establishment of this international oversight and governance organization is a crucial step in addressing the multifaceted challenges proposed by AI and quantum computing on a global scale. Such an organization would leverage existing legislation in the US and EU and other parts of the world as a basis and tackle issues that may require transnational and transregional coordination. As such, it represents a commitment to innovate ethical and equitable development in these critical technological domains. Thank you very much.
Thank you for that talk. Does anyone have any questions?
Thank you very much for your very insightful presentation. And by the way, I love your slides. They're beautiful.
Mention that the pictures are made by ChatGPT-4.
Nice.
Yes.
Right. Okay, so two quick
So
ones.
also I want to mention that my collaborator Dr. Ali Mostashari can also answer questions if it's possible that he could get connected.
I don't think he's joined.
He did, I think. No? He sent a picture of me in the presentation.
Maybe he's watching on YouTube, but he doesn't have the Zoom link.
Oh, okay. Okay, so happy to answer.
All right, so two very quick ones. Maybe you have it, I may have missed it, or missed them, but two very quick ones. One is funding, and the other is accountability. Have you considered those two issues in respect of a central body, sort of, because obviously this will require a lot of money. And so the second one on accountability, being that because many member countries are going to contribute to this initiative in one way or the other, for such treaties under international law, more often than not, the states would have some obligations in the form of accountability. So what's your stake on these two issues in respect of your proposal? Thank you.
Thank you. So funding would come the same way as other multilateral organizations. Just that's the idea that we have. But he's my colleague who is helping me with answering. But because big tech will also be involved, there are more resources for funding. Because we are proposing that tech companies also join the discussions. So there will be funding from the tech companies as well. Thank you.
Thank you. Any more questions, or we can go on to the second part of the presentation? Okay. AI and accountability under international law, bridging the state responsibility gap. And it's going to be Fred Kusim Awindaga presenting. So yeah, feel free to go when you're ready.
All right, so thank you very much for the to present. So I'm Fred Kusim Awindaga, as Obi rightly mentioned, and I'm a PhD candidate and research fellow, Center for Finance and Development and the Geneva Graduate Institute. All right, so AI and accountability under international law, bridging the state responsibility gap. Right, so AI has been addressed extensively in the realm of law, but international law perhaps may be lagging behind on the issue of artificial intelligence. At the same time, I'm convinced that international law is the proper domain because, as we would all perhaps agree, AI really doesn't know boundaries. It transcends beyond boundaries. It's one of those concepts that does not restrict itself to national boundaries, if I'll put it that way. And because of that, it directly challenges the Westphalian concepts of international law in the sense that international law is basically, around national borders and beyond. That's what international law is basically about. And AI is one of those concepts that goes beyond borders, and therefore, ordinarily, one would assume that international law would be a front runner in confronting the issues of artificial intelligence, but that may not necessarily be the case, and that's the motivation for this work. Now, with the euphoria going on with AI, one thing also in the background is an AI race, which is normal for many upcoming developments that usually have some power attributes to them. We saw that with the nuclear arms treaty, and then with the nuclear arms race and other concepts in the past. And Vladimir Putin has been bold enough to say that whoever wins the AI race is likely to be the leader of the world, like it happened with the nuclear arms race and other races in the past. At the same time, what's creating a lot of the euphoria is the idea of an existentialist threat. And many people have shared the opinion that AI could lead to the extinction of humanity. Stephen Hawking, for example, has intimated that should we get to a point where artificial intelligence supersedes human intelligence and the values of an artificially intelligent machine do not coincide with the values of humanity and contradict the values of humanity, then we are in danger. A lot of people in Silicon Valley also share the same view, but not everyone necessarily does. Daniel Dennett, for example, is of the view that we are distracting ourselves from the immediate needs of artificial intelligence by concentrating so much on the existentialist threats that are posed. And so he thinks that there are more immediate concerns we should devote our attention to. So that leads us to regulation. In the meantime, what do we do while waiting to see whether indeed there's an existentialist threat or not? So we regulate. But in regulating, we seem to have lost sight of the fundamentals. And the motivation for me looking or being concerned about the fundamentals, especially under international law, is that listening to Paul Krugman, for example, sometime in 2016, when he presented in Geneva, is the Nobel Prize winner for economics in 2008. He was asked what happened with the global financial crisis. How come no one saw it coming? And his response was that he thinks that we lost sight of the fundamentals of economics. We're all busily concerned about the modern tools and forgot about classical economics. Elon Musk has shared similar views when he was asked if he was not going too far with the frontiers of technology and all that, going to Mars. And he said that quite the reverse. He said he also intimated that he thinks not, and that there's so much we gain fundamentally and we lost because we lost sight of the fundamentals. He gave examples of how, for example, the pyramids, no one remembers how the pyramids were built and all that. So that got me thinking a lot more about the fundamentals of international law and what role that has to play in AI frontiers. And so within international law, the issue of accountability is important. Yes, it's almost forgotten in this strive to regulate AI. The importance of accountability within international law has been highlighted by many people. Rosalind Higgins, first president of the ICJ, female president of the ICJ, Kofi Annan, former Secretary General, and the current ICJ president have all intimated how we often talk about accountability within domestic law, but accountability at the international level is even more important, yet little attention is paid to it. Now, within the international law framework and accountability, what stands out is attribution of state responsibility. And the idea about state responsibility is that how do you hold governments accountable for wrongdoings under international law? We have it in two legs. One is where state organs are concerned, and then the second is where the actions of private persons. So to give a bit of context, when actions of state organs are concerned and there's an international wrongdoing, government is supposed to be held responsible. And that's the notion of attribution. This has been held in a number of cases. The Kerr case, where members of a revolution went beyond what was commanded by their commanders, and the state of Mexico was held responsible. It has come up in different other contexts, so that the International Law Commission in its draft articles of state responsibility has held in Article 7 that once state organs are concerned, whether they stay within or beyond their command, the state will still be held responsible. Now, how does this apply, or how is this amplified within AI? Now, AI, as we all know, especially with generative AI, the machine can think on its own. So what happens if the deployment is under the command of government? For example, if it's a spy machine working through one of the state security agencies, and it goes beyond what was initially instructed, as it can think for itself, who do we hold responsible? Is it the manufacturer of the AI? Is it the state that's going to be held responsible? And so this is an old issue within international law that wasn't fully resolved, and now with AI would tend to be amplified. The next one is actions of private persons. So this, for example, is a situation where within a country, the person who is acting is not under the control of government, but it's within the government's territory. So under international law, the classic case was the Tellini case, where an Italian general, Tellini, was killed on what was supposed to be Greek territory by private persons. And this led to a dispute between Italy and Greece. The issue was this: can Greece be held responsible for the actions of private persons who killed General Tellini on Greek soil? Now, how does this, and this happens in several ways, but to the extent that the international courts have laid two tests: effective control and overall control. Effective control in the sense that the private persons must have been under the direct control of the government. And then the overall control is that even if there's no direct control, but some way, somehow, there can be a link to the government will still be held responsible. But that still leaves some gaps. For example, what if it is so indirect? Who do we hold responsible? So this is a problem within international law that has not been resolved. And then we are confronted with AI, which has amplified this issue. For example, if, let's say, I give an example. In Ghana, for example, persons were allegedly Russians influenced the US elections with machines that were operated from within Ghana territory, okay? So what happens in such a situation? Had it been AI controlled? Ghana has nothing to do with it. It's in the territory of Ghana. It's done by Russians. The victim is the US. Who do we hold responsible? Russia, Ghana, how do we work it out? So the point here being that these are not new issues. They are old issues that were left unresolved. And now AI has come in to amplify these issues. Now, within or beyond state responsibility, international law itself has other challenges that even make it more difficult to resolve the issue of accountability. For example, the sources of international law, which are supposed to come from Article 38 of the ICJ or International Court of Justice Statute, where treaties, for example, are the foremost sources or are the foremost source of international law. Now, the problem here is that most of the sources of international law are static, are not progressive enough, and so are unable to respond to new issues that emerge. Singleton Cabbage, for example, has mentioned that because of the sources of international law, phenomena such as climate change are dragging on because international law always lags behind. By the time we rely on the sources to deal with the issue would have progressed from what we originally know it. Now, to the extent that the EU regulation, for example, which perhaps will be the closest to an international law treaty, has come up several years after AI. And so that makes it less proactive. And this is not the only issue. The other issue about international law as a whole, in terms of responding to issues of accountability, especially with AI, is the issue of international law being overly cautious. Now, this caution from international law stems from principles such as the precautionary principle, where when an issue is based on risk, the courts, international courts, are usually careful. Now, the AI conundrum is rooted within this risk principle. And once again, that issue is going to come up. Now, in conclusion, how do we deal with this issue of accountability within international law and AI, bearing in mind some of the issues that have been outlined? So one of them is that perhaps we need to rethink the sources of international law, so that beyond the traditional sources of international law, we need to look at soft law in the sense that there could be other sources of law outside the traditional sources, which are a lot more progressive. And some people tend to look down on soft law as not being law properly so-called, but not everyone agrees. Dupree and Philip Sands are of the view that they are equally law as long as they are representative enough and have the core values of international law. Another way around this issue of accountability may be the notion of non-state actors, in the sense that there are other personalities that could be elevated on the status of international law, on the stage of international law, in the sense that not only states should be given personality, so that individuals and corporations, for example, could be given international personality, so that if a corporation can be held directly responsible for an AI malfunction, why struggle to hold a state responsible when indeed the non-state actor in the form of the individual or the corporation involved will be held accountable? So finally, in looking at this accountability framework, or trying to hold or push forward the notion of accountability, we should look at it holistically. Otherwise, the gaps would remain. All right, so thank you all for your attention.